The Constitutional Court has given former President Jacob Zuma until tomorrow to file an affidavit detailing an appropriate sanction for him should he be found to be in contempt of court. The former president defied summons to appear at the State Capture Commission of Inquiry earlier on this year. He continued to defy a constitutional court order compelling him to appear before the commission. The commission has asked the court to find the former president in contempt of court and have him imprisoned for 2 years. For more on this, I'm joined on the line by Professor Richard Calland, a constitutional law expert. A very good afternoon to you, Professor, and thank you very much for your time. Let's talk about the actions of the Constitutional Court. Is there a legal precedent? Is there a precedent that has been set before where the Constitutional Court actually asks an accused what sanction should be applied in their case should they be found guilty? Is this something new or not?
Good afternoon, Tammy. I don't know about precedent, but certainly this is highly unusual. I think if you or I were to defy a court order, if we were to fall behind in relation to some payment program that had been confirmed by the court, and we were brought back before a court on the basis of contempt proceedings, and then we didn't show up and failed to make representations to the court, it is very unlikely that the court would go the extra mile to ask us to specifically respond to the question of what kind of penalty we should face. And that, in effect, is what the court has done. It's gone the extra mile, yet again, I might say, in respect of Jacob Zuma. We can speculate as to reasons why that would be, but I think the short point is they want to make it absolutely clear that he has been given every opportunity to put his side to the court before they reach the conclusion that they must reach, which I think is more likely not to include a penal sentence.
So let's talk about one of the likely reasons there, which you mentioned, which is to give the former president an opportunity to give his side of the story. What are other alternative ways that could have been used to achieve the same end, bar asking the former president what the sanctions against him should be?
Well, that's what they've done. I don't think there was any other option other than to proceed with their decision-making, their adjudication of the matter, and to, in effect, pass sentence upon him. And I think they, on one level, have been put in a bit of a corner, the Constitutional Court, because in an adversarial system, such as South Africa's, where two sides argue a matter, if one side fails to appear, fails to send representations, and essentially shuns the court, then it's very difficult because they then are faced, in a sense, by only one side of the argument. And this is no ordinary case. So whilst earlier I suggested that you or I would have this kind of special opportunity to put our side, this is no ordinary case. It involves a former president. It's a former president refusing to go before the Commission of Inquiry that he himself was required by the public, then the court itself. He has basically shown, rather clumsily and bluntly, shown the mingle, not just to the Commission, but also to the Constitutional Court. It's made some really scandalous allegations, unfounded allegations, outside the integrity, about alleging fraud and other conduct on the Constitutional Court. So he's put in a position. He clearly win this in the court of public opinion. He tries to create a political here, having run out of legal runway. And in turn, what the court on Friday did was to throw the ball back into his court for one last time and say, provide us by Wednesday with arguments as to why you should, in effect, not go to prison as a result of your contempt, or we may have no other choice.
You mentioned the adversarial environment that we live in. There's a political analyst who has coined this as a legally prudent act. In the context of the politics that mingle with the legalities, how would you define this act by the Constitutional Court in trying perhaps to bridge the two potentially?
Well, I think it's legally prudent, legally cautious, and legally highly unusual. And I think the driving motive may be a concern about the political milieu and political consequences of where we find ourselves with this matter. This is all of Mr. Zuma's own making. Let's be quite clear about that. He has refused to cooperate with the Commission of Inquiry. The Commission of Inquiry, led by Deputy Chief Justice Ondo, felt compelled, I think, good reason to bring a matter to the Constitutional Court. The Constitutional Court considered it very carefully, said he must appear in front of the Commission. He's refused to do so. He's refused to then appear in front of the Commission. He's shunned it, defied it by refusing to make any representations. So they're in a corner. That's not a constitutional crisis. This is the system working. Mr. Zuma intends, I think, to make a political crisis of this. And what the court has done is shown that it's not unaware of that political milieu, and it is played very carefully to give him this one last chance. By doing so, as I said right at the beginning, it will be impossible, I think, for Mr. Zuma to fairly or reasonably argue that he was treated unreasonably or unfairly by the court. He's been given an extra opportunity that ordinary citizens would not be given to put his side of things and to argue as to why he should not be found in contempt and not be penalized, probably with imprisonment.
You've said that this is not a constitutional crisis. You've said that this is actually a sign of the system working. Is there a potential of this backfiring in any way? Should the former president come back and say, I don't believe that there should be any sort of sanctions to me, or that perhaps I should be fined 5,000 rand or whatever the figure may be, what then does that do for the Constitutional Court, and what then are the obligations of the Constitutional Court of the recommendations that will then be made potentially by the former president?
Well, again, Tammy, I would say that that is the system working. If he chooses on this occasion, at the last moment, the 11th hour, to respond to these directions issued on Friday, unusual though they are, he decides to be constructive about it and to make submissions, then of course the courts weigh those carefully in the balance. They will then have reason in their adjudication of those matters and reach a careful conclusion. That's the system working. That's the Constitutional Court working. That is our rule of law working. All of this is extremely good news for those of us who believe in the Constitution. Of course, Mr. Zuma's latest approach to this matter has been to suggest that, in fact, the constitutional democracy is in some way fraudulent, is some way lacking, and that we should be doing away with it and returning to a system of parliamentary sovereignty in which the parliament is sovereign and not the constitution.
So what are the implications, the long-term implications for the Constitutional Court?
Well, my belief is that the majority of people in this country are satisfied with the system of constitutional democracy. They want to see justice done. They want to see people who have been abusive of the power and responsibility that has been given to them held to account. And that is what is happening here through the Commission of Inquiry appointed by the President, the Zondo Commission, and indeed by the court system. One by one, slowly by slowly, public accountability is being enforced through the rule of law. That proves that this is a real constitutional democracy. It's working well in practice. Of course, there are arguments and contestations, but that indeed is part of what a constitutional democracy is about. It's not an autocracy. It's not someone with a huge amount of power from the top decreeing what should happen. That, in fact, is what happened under Mr. Zuma's rule. He sought to undermine the Constitution, as we're hearing day after day in the Zondo Commission. He sought to undermine that, effectively creating a shadow state, stealing the promise of democracy that was hard won all those years ago in 1994.
So, Professor, there is what the former president may want, should he choose to respond, in writing and put together that affidavit. But there is also what the State Capitol Commission of Inquiry has recommended, what they say they want, which is a 2-year jail term for the former president. In issues of this nature, this 2-year jail term, would this be a standard penalty for such?
Tammy, to be perfectly blunt with you, I don't think there is a standard penalty here because one is dealing with a really exceptional case. This is not a run-of-the-mill case by any manner or means. This is a former president of this country elected on 2 occasions by the National Assembly to serve as president of the Republic of South Africa. He now has chosen of his own volition to break the law, to fail to act in a lawful manner in response to the subpoenas of the Zondo Commission. He's defied the Constitutional Court. He's undermined or sought to undermine the rule of law by making the most scurrilous, unfounded allegations about the integrity of certain judges and indeed the Constitutional Court. So this crisis, as far as it is a crisis, is of his own making. And in that sense, it's a difficult moment, and it will be a difficult moment if the court finds that it has no alternative but to sentence him to a term of imprisonment. It will be a very awkward and embarrassing for the country. But South Africa is resilient. It's proved its resilience time and again. I believe it will get through it.
Professor Calland, thank you very much for your insight on this matter. That's a constitutional law expert, Professor Richard Calland there.